Now, again, you understand that I'm not bound to follow any recommendation, and that would include following the IDIP guidelines.
Yes.
I could sentence you all the way up to the maximum possible penalty, again, if I thought it was warranted. You understand that?
Yes.
Do you have any questions for your attorney in the court before we proceed? And there's all kinds of fun today. Okay.
So,
All right. So you understand I could sentence you to the maximum penalty? Any questions?
just one. It's just. Oh, next question. I just want to know.
Here we go, the classic courtroom trap. The defendant thinks he's uncovered a loophole through math, but courts don't run on YouTube logic or AI screenshots. Blood alcohol numbers aren't casual decimals. They're standardized scientific measurements backed by statute. Viewers, this is where confidence without understanding starts to become dangerous.
Math is usually not fiction. Why is math?
Yes, just like it's fine. Right. How it works. I'm pretty good at that.
Want me to get a math professor in here to explain it? Because I'm not a mathematician.
That's what he said.
That he's not a mathematician because he's not. Because quite honestly, we go to law school, so we don't have to do math. But we have to do math in our job. What's your question?
Just, she's that's what.
I don't know what this is.
What's happening?
No, what is this, Mr. King?
I think it's wait. The issue and where I'm with Sanderson is he had a question about the grams per 100 milliliters,
Dude,
and
that's a scientific question. You can call up the scientists or the lab analysts that do that. I'm not in charge of that. And
This is a key legal distinction most defendants miss. Judges don't invent BAC limits, and scientists don't enforce laws. The legislature sets the rules, labs provide the data, and judges apply both. When someone argues math instead of law, it tells the court one thing. They're fighting reality, not evidence.
the legislature makes up the laws. I'm in charge of following and enforcing the laws. So what's your question? You think that you were below the limit, above the limit, beyond the limit, how they came up with the limit?
According to this, I was not.
Yeah, and that's a AI chatbot thing, right?
Yeah.
Yeah.
Maybe it's wrong.
Yes.
An AI chatbot?
But
Are we using artificial intelligence?
it's just that I was measured in thousands. The law goes by hundreds. Well, the trial, if you want.
I am so great to have a trial. I love having trials, especially when the lab analyst comes, and especially when then it completely opens up to the maximum penalty. That's great and fine with me. Is that what?
This moment is brilliant judicial chess. The judge flips the script. You want to argue science? Fine, let's bring in experts. But here's the catch. Going to trial exposes the defendant to maximum penalties. This isn't encouragement. It's a calculated reminder that pushing weak arguments can make things far worse.
You wish to do and have a lab analyst up here to explain all of the scientific reasoning behind the calculations and behind their testing?
Just take me to jail.
Okay, I think that's his way of saying is rushing past it.
All right. Okay. So, now, did you review the criminal complaint with your attorney? And it has all of those facts that says what happened that day from the officer's perspective and from your perspective, because you said, I only had 1 or 2 beers, which we know isn't actually.
I had 0. I had drank in the night before.
So then you drank a lot more than 1 or 2 beers the night before.
I had a six pack of 16 ounces, 16 ounce.
And yet you blew a .221, allegedly in the criminal complaint.
Yeah, and that's what I'm saying is 221 is thousands, not hundreds.
Oh, Mr. Lamprecht. Mr. Lamprecht. It's .08 in Wisconsin to be legally drunk. And for 1 or 2 beers or a 6-pack or whatever you said the night before, unless you are a chronic alcoholic who drinks all the time, you won't wake up the next morning to blow a .221.
This is devastating for the defense narrative. A .221 BAC isn't borderline, it's extreme. The judge dismantles the night before excuse using real-world physiology. For viewers, this is how courts separate excuses for facts. Blood doesn't lie, and labs don't guess.
Impossible.
Exactly.
But you did. And we have lab, right, Mr. Renicky?
Lab.
What does lab say? Where they tested it with scientific stuff.
I didn't need to put you in a bad mood.
0.19. You did by starting by being late. Okay? You're not supposed to be late to court. Okay? You're supposed to be here early so you can meet with your attorney. And quite honestly, and it's taken you months and 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 months to do the IDIP program. I gave you yet another chance. And now you're here debating science.
Anytime you put a numeral behind the decimal, like 1 numeral behind the decimal is 2 numerals behind the decimal is 100.
Yep.
3 numerals behind the decimal is 1,000.
Yep, I know math.
Okay. And 1,000 is 10 times less than 100.
Well, let's cut that off, okay? You blew 0.22 with a PBT.
221.
Or 0.221, okay? So let's say you will get off the 1, because that's what math does. You get a cut off certain things. So you were 0.22. We'll give you a benefit of the doubt. No more with that 1. That 1,000's gone. So you blew a 0.22. But lab came back and said, guess what? We ran his blood, which is more accurate. And it gave us a better truth of what happened. And it was 0.19. 0.19. It's 0.08 in Wisconsin to be legally intoxicated and operate. So you get it now? You understand now?
I don't understand how 1,000 is 100.
I cut it off. I agree with you. I'll give you the benefit. I cut that off. It's 0.22. It's 0.22.
No, if there's 3 numerals. Yeah, because if it was point.
Mr. Renicky, I'd love to have a jury trial because it sounds like he doesn't understand the science and he wants to have a lab analyst here. Is that right, Mr. Keene? Is that what I'm hearing? He wants to have a jury trial because we can facilitate that next week.
I'm just saying what math.
I had a jury trial come up, not next week, the week after. You can get a jury trial. Is that what you want? You want to fight that issue of this extra 1,000 in the decimal point?
It's not an extra 1,000. No, it's 1,000 thirds, not.
Okay, 1,000 thirds. If you want to go to trial over that and have the lab analyst explain it, because I'm going to tell you, she is far smarter than I am when it comes to science and to explain it to you, then maybe you'll be able to understand. You won't be able to ask her questions.
How about this? Can I just go to jail? And I'll give you this copy.
I don't need the copy.
And then, so give me the knowledge because I like it.
Here's what you can do to gain knowledge. Call up a lab analyst, have them explain it to you. Because that's what happens in a jury trial, and I hear it. It goes on for hours.
I'm not trying to piss you off. Take me to jail, I'm fine with that. Have the money, finally, last month. Been very giving, lenient with me, and giving extensions. So, okay. Yeah. I'll go to jail. No, I got a job.
All right. So, Are you admitting that you at least blew over a 0.08 or at least 0.08 at least blood alcohol content was in your blood at the bare minimum?
I agree that I blew a 0.221, and I agree that my blood alcohol was at 0.190.
Okay. All right.
I agree with this.
And do you agree that you operated or drove a motor vehicle while in that state?
I agree with that, yes.
All right. Mr. Keen, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, Your Honor.
Has anyone made any threats to you, Mr. Lamprecht? Any promises for you to plead guilty to this charge? Has anybody promised you anything? Hey, we're going to give you $1 million if you plead guilty. Or we're going to give you some kind of benefit if you plead guilty, other than this offer and guidelines.
The only thing that I've been told was if I could get out, keep my job, keep my place, keep my things.
Okay, so that's not a promise. Anyone threaten you anything? I'm going to beat you up. I'm going to take a gun. I'm going to take a knife. Anybody threaten you or anything?
Yes.
Okay. Are you pleading guilty with a full understanding of what you're doing here today?
Yes, I'm pleading guilty to blowing a .221 and having a blood alcohol content of 0.190.
All right. And you're pleading guilty voluntarily. Does anyone threat, or are you satisfied with your attorney's services?
Yes, 5 out of 10.
5 out of 10. Has he done a good job in the fact that he's looked to see if you had defenses? Because I'm going to tell you, your argument here is crap. I don't say crap in court, it's crap.
I'm just trying to conversate. I'm not trying to argue.
This isn't a conversate time, okay? This isn't a time to conversate. This is a plea and sentencing in which you showed up to court 18 minutes late.
I forgot my line. I apologize.
Has your attorney talked to you about the case? And has he looked at everything and discussed with you everything that he's seen in discovery?
Except for my one question.
All right, because he's not a scientist. But he said you can figure that out. Talk to a scientist, right?
I don't know.
Mr. Keene, you said that's not a defense, correct?
And yes, and we have discussed that basic math and other things extensively.
All right. Okay. You have any? No. All right. So, based on this, the OWI third, count 1. How do you wish to plead? Court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count 1. Count 2 will be merged and dismissed as count 1. A judgment of conviction will be entered today. Mr. Renicky, argument, please.
Kind of amazing. In any event, so no WI. There was driving, but no accident. As the court is aware, it's a .19 PAC. And this is his third OWI. He did complete the IDIP program. He still has, at least at the time of my letter from Jess Anderson, he had just dropped off the last $200 to complete the IDIP. But he needs to come up with a down payment for the electronic monitor as well as the booking fee. He was booked and released, so he's not 48 hours. Because of the IDIP completion, and consistent with the plea agreement, we would ask the court to follow the IDIP guidelines for the 1-9 on the third offense, which I believe is $1,911 for fines and costs. It's a blood draw, so there'd be a $10 blood draw, 45 days of jail, 24 months of ignition interlock, 75 hours of community service, and 24 months of revocation.
Yes, sir. I think this agreement recognizes both that alcohol use is an issue in the community. It has provided some rehabilitation needs because he has done some community service to, deal with the harm to the community. Although again, no accidents happened. He was for the period of the IDIP, which is longer than normally, in the court by a substantial factor, had to blow into a tube and verify that he was not under the influence of alcohol. Yeah. He also, just with an OWI-3, he would have a blood alcohol content restriction 0.02, which means I'd be careful about even non-alcohol alcohol, because the 0.02 is nothing for the next 2 years. And it does have the future deterrents because any OWIs after this are felonies with a minimum of 1.5 years in the Wisconsin prison system. Because OWI-3 is the last one, still considered a misdemeanor. So I think that although it's a painful process to get here, the court should stick with the agreement because, the pain, but Solantic has met the terms of the IDIP, albeit not in normally prescribed time. The agreement does serve the goals of trying to get pre-sentencing rehabilitation done, and there's substantial deterrence to protect the community's interest because of just the fact that it's an OWI-3 and the ignition interlock provides that for 2 years plus substantially greater penalties on any future sentences. So I would ask the court to stick with the agreement despite the less than beneficial behaviors at times exhibited by Ms. Robert.
Thank you. Mr. Lamprecht, anything you want to add or say to the court?
So, do not have an order.
Well, what are you doing in employment license if you don't know?
You don't have a job.
Okay.
He has a job, he has a life, they're waiting for him after he's done here today, which is all a positive thing. It's all about rehabilitation. OWIs are very serious. I don't make the law. The legislature makes the law. I don't determine the science. The lab analysts go to school for years and years and years and years and years. The lab analysts, they learn science, and they learn how to read scientific data. So they are the smarter ones in the OWI matters. I know the law, I see the law, I read the law, I enforce the law, I ensure that that the community is protected in certain ways. OWI is, again, serious. You're putting yourself at risk, you're putting others at risk. The fact that you blew a .221 at blood alcohol content from blood at 0.19 is serious, especially given
190. Sorry for that.
Don't interrupt me again. You interrupt me again, and I will hold you in contempt. I will hold you.
This is the courtroom endgame. The judge is no longer debating. He's commanding. Interruptions are over. Patience is gone, and consequences are locked in. When a judge says 0 tolerance, believe it. One mistake, one mispayment, one decimal of alcohol, and the system snaps shut.